Welcome back to the Diary of a Ghanaian Lawyer, the podcast that opens up the courtroom, the chambers, and the corridors of legal practice in Ghana. I'm your host, Lawyer Fredericka, and today's episode is one of many that you have requested, and one that I personally love: how to cross-examine like a pro. Now, whether you are preparing for your first trial or you already earned your stripes in litigation, this episode is packed with practical strategies to help you take control of the witness box and ultimately the courtroom. Let's start with the basics. What is cross-examination? Now, cross-examination is the process of questioning a witness called by the opposing side or even the court itself. It's not just about asking questions. It's about controlling the narrative. It's about testing credibility and creating reasonable doubt where needed. There's a famous quote by Clarence Darrow which says, "Cross-examination is the greatest legal engine ever invented for the discovery of truth." But here's the thing. It is also the most dangerous thing if not done properly. Now, cross-examination isn't just about asking questions. It is strategic, it is psychological, and is surgical. Yes. In Ghanaian courts, the witness is put in the box, he swears on oath, then his or her lawyer would lead him to tell his story, either by using the old tactic of asking non-leading questions. That's what we call examination in chief. Or they file a witness statement and then they tender it as evidence. Afterwards, the opposing counsel then approaches the witness and cross-examine. It is there that you have the moment to test the truth or otherwise of the story told by the witness during the examination in chief. Now think of it like this. The examination in chief tells the story. Then the cross-examination tests whether that story holds water. So what are we really trying to do during cross-examination? 1, we are trying to discredit or challenge the testimony given during examination in chief. 2, we are trying to expose the inconsistencies or the biases in the story. 3, we are trying to plant seeds of doubt in the witness's story. 4, we are trying to highlight facts that support your theory of the entire case. Now, how do you achieve all these? The thing is, every good cross-examination begins outside the courtroom. That means preparation is very key. So kindly take notes of these pointers. Point 1, know your case theory. Don't cross-examine in a vacuum. Every question should advance your version of events. Are you proving mistaken identity, alibi, fabrication? You must have a clear and consistent theory of your case. Then you go ahead to show us what you are trying to prove or what you are trying to disprove. Every question should support this goal of yours. Feel free to reach out to us on any of our platforms for specific guidance on how to approach, say, a land matter, a criminal matter, a contract matter, and the rest. Now, point 2, know the witness inside out. How do you do this? You review their pleadings. You ensure everything in their witness statements has already been pleaded. If they introduce new facts not pleaded, you pray for the court to strike it out. Now you review any previous other statements they have, the affidavits, any discovery documents. Look out for contradictions. Have they said something different elsewhere? Note them down and establish their inconsistencies. Check the documents attached to their witness statements that they seek to tender as the evidence in chief. Do they require special stamping or registration? Did they author it? Are they legible? Do they have the originals or certified true copies? All these are very important. Now, point number 3, draft your cross-examination questions with precision. Write down your questions if need be. Organize them by topics or paragraphs by paragraphs. You can also note down points you want to establish so you don't lose your train of thoughts whilst cross-examining. But don't stick to the drafted questions only. Focus on their answers too, as the answers can give rise to follow-up questions. Now, the questions or the topic you note down, they help you keep track of your line of questioning to ensure that you, the lawyer, you don't lose sight of your goal for cross-examination. But don't stick to those questions blindly, and don't make it so obvious that you are reading your questions out. Please be intentional about cross-examination and don't just wing it, because sometimes the courtroom pressure can mess with your mind or your decision to just be spontaneous. It can make you lose your train of thoughts. So draft and then take notes whilst cross-examining. Let's break it down further. In drafting your questions or crafting them, you must note these techniques. 1, don't ask non-leading questions. Rather, ask leading questions. Yes, your questions must be leading. What does this mean? This means that you must suggest your answer in the question. For instance, instead of asking, where were you on the night of June 3rd? You have to ask, you were at Ridge Hospital on the night of June 3rd. Is that not so? That is much more suggestive and leading. This advice is for points you cannot afford to miss in establishing your case. Sometimes lawyers choose to let the witness wander a bit just to throw them off. Sometimes this tactic works, other times it just confuses everyone in the courtroom. Make sure that at the end of cross-examination, your defense is obvious from your line of questioning. Now, another point is keep the questions short and controlled. It has to be one fact per question, and try your best to not let the witness narrate. For instance, instead of asking, can you tell the court what you saw that night and what you think you saw? You can just ask the straight question. You didn't see the accused clearly, did you? Much better. Now, another point is listen to the witness like a hawk. Don't just run through your scripts or your drafted questions. Listen carefully for questions that open up new angles or statements that contradict earlier statements made. This means that you should take notes when cross-examining too. Ideally, you should have already had an expected answer for each question that you ask your witness. Yes, you have to try as much as possible to not ask questions whose answers you do not know or have intel on, lest you might be surprised and it can throw you off as a lawyer. Another point is learn to trap witnesses with contradictions. This works when you listen attentively to the witness. If a witness contradicts their prior statement, confront them with it. If a witness says one thing today and something different in a police statement, you gently corner them. For instance, so you're telling this court that you saw the suspect at 7 p.m.? Of course, you say yes, but then you follow up with a question. But in your signed statement with the police, you said 9 p.m. Is that not so? You might catch the witness fumbling or formulating some afterthought stories. Now, another advice is learn how to use repetition for emphasis. Now, this tactic it should be used selectively and not always, because the judge might stop you or the other lawyer might just object to your line of questioning if you just keep repeating. Use repetition selectively to emphasize absurdity. For instance, This is a cross-examination between a lawyer and then the witness.
You didn't see the person's face,
No.
but you are certain he was the accused.
Yes.
It is your case before this court that you didn't see the face, but you are sure it was my client. You didn't see the person's face.
Now, such questions, they expose the witness. You let the illogic of their statements do the damage to their own case. Now, there are some common pitfalls you have to avoid during cross-examination, and even experienced lawyers fall into these traps. So kindly note them to keep you sharp. 1. Don't ask questions you don't know the answer to. Don't argue with the witness. Argue your case during the closing or your written addresses. Don't let the witness explain too much. Don't overdo it. Sometimes less is more. Don't forget your tone. Sometimes aggressive cross-examiners often alienate the judge or the jury. And in fact, judges may interrupt or caution you if your tone is deemed intimidating or disrespectful, even if your strategy is sound. And when the judge prompts you, you express your gratitude by saying, "Most grateful," or "I'll take a cue from the bench." See, cross-examination is about effectiveness, not about your ego as a lawyer. You have to pay attention to the witness's face, the witness's body language to know which questions destabilize him or her. As a lawyer, you have to be a good actor too. Don't show when an answer spoils your case. No, you need that poker face. Also, you have to speak clearly and give the judge or the recorder time to record your questions and the witness's response. Many courts in Ghana, unfortunately, still rely on handwritten notes. So pacing yourself as a lawyer is very important. Give the judge time to write your questions and the witness's response. Learn to use polite courtroom languages like "my lord," "my lady," "as the court pleases," and the like. Also, when cross-examining experts like police officers, medical officers, auditors, remember that they are often seen as credible witnesses by default. Your strategy must be even more precise. Focus on inconsistencies in documentation, focus on timelines or lack of procedural compliance. Conduct research on your own. Ask other professionals for their opinions and what they would have done differently. Then you proceed to establish your defense through cross-examination. To cross-examine like a pro, you need more than confidence. You need preparation. You need focus. You need control. And you need respect for the courtroom dynamics. Master it and you are well on your way to become a courtroom star. You can read more on cross-examination by getting books like The Art of Cross-Examination by Nat Heward Mills, The Art of Cross-Examination by Francis Wellman, or 10,000 Questions for Cross-Examination of Witnesses by Vivek and Dr. Gupta. Now, to our story time for this episode. The title is The Lawyer's Confession. Now, let's hear it. The clock on the wall was belling 10 p.m. It was a Tuesday evening and I was enjoying brandy and coke and a game of Scrabble with my girlfriend in my living room after a hard day's submission of no case to answer in an attempted rape case. Suddenly, we heard erratic bangs on my front door with the accompanying shouts, "Lawyer, open! Lawyer, open!" Who could this be disturbing such a tranquil romantic evening with my girlfriend? We rushed to the window, pushed aside the curtain, and looking through, we saw a taxi with a blood-stained driver standing in front of my door. "Who are you?" I asked. Come out, lawyer," he demanded. I have killed somebody. I need your help," he entreated. "With your taxi?" I inquired. "No, with this knife," was the reply as he pulled out a blood-stained knife. I asked the lady to get inside as I opened the door. With the two of us standing by his taxi, I demanded him to narrate the incident. He was having an affair with a married woman in his own room at a house near Amakum Market, Kumasi, when suddenly the husband appeared, broke open the door, and saw the two of them in action. In the ensuing struggle to escape, he grabbed the woman's kitchen knife, stabbed the husband twice in the chest and once on the neck. As the husband fell down, he managed to escape with the knife. He claimed he did not know the woman was married. "Where was the woman?" I asked. "She had run out for help," he answered. "Were you hurt in the fight?" I inquired. "No," was the answer. "Not any part of your body at all?" I demanded. "No," he insisted. "You killed the husband?" I wanted to know. "He should be dead by now," was his reply. This was not the time for dialogue, but time for defense. The woman was not in the room. The husband had every reason to fight, stab, and even kill either of them. Unfortunately, the husband had turned out to be the deceased victim at the hands of the adulterer who had managed to escape unhurt. "Of course, you were defending yourself from this man. He turned beastly at the sight of seeing you and his wife in the room. So what did the man do?" I inquired. "Nothing," he replied without getting my message. "Nothing? You fool. What would you have done if you were the husband?" was my follow-up question. He bowed down for a few seconds and replied, "I would have killed the bastard." "So the husband wanted to kill you," I retorted. "And wouldn't you defend yourself?" Quickly, he got the message. The taxi driver had some monkey sense. He pulled out the knife and slashed the lower part of his left shoulder. As blood was oozing out profusely, I asked him to drive to the nearest police station at Asokwa to report the case. He was not to tell them he had stabbed the man to death, but that in the ensuing battle of knives, he managed to escape to report the matter to the police. At the station, the police impounded the taxi and also detailed one policeman to take him to Okonfanoche Teaching Hospital. They also dispatched one policeman to the scene of the incident, where he found the husband dead in a pool of blood from multiple stabs. The deceased was also taken to the Okonfanoche Hospital. In the follow-up trial of murder case before Mr. Justice Samson Baidu at the Kumasi Assize Court, the autopsy report on the deceased read as follows. James Kofinsia, a heavily built young man in his early 40s, died of multiple knife wounds at his chest and neck. The medical reports from the same hospital also read as follows. Kweku Karten, a taxi driver aged 37, was rushed to the Okonfanoche Hospital at about 11:30 p.m. with a deep knife cut at the lower left part of his left shoulder. Since there were no eyewitnesses in the room at the time of the alleged duel of the knives, of course, I built my defense as counsel for Kweku Kwarten on self-defense. It was a trial by a jury of 6 men and 3 women. This was the case where over 100 taxi drivers in Kumasi would come to the court in solid comradeship with their mate, Kwarten. The taxi drivers had passed over to me all they knew about the private lives of the jury. At least 2 of them were flirting with other people's wives, and one of the 3 ladies of the jury was also engaged in an affair with a senior police officer. All the jurors were Christians, and in my address to them, I sermoned them on the prostitutes, the stone throwers, and Christ, and provided them with 9 stones to throw at Kweku Kwarten if they considered him guilty. Notwithstanding the judge's brilliant direction to them of the alternative verdict of manslaughter, if they were not convinced beyond reasonable doubt that the case was murder, the jury unanimously returned the verdict of not guilty of the crime. Kweku Kwarten, who had been in remand custody for over 6 months, was set free immediately. I managed to rescue him from his jubilating taxi driver comrades and put him in my Morris Minor car. But no, the taxi drivers left their cars behind and followed Kwarten and I in my car to my office about 2 kilometers away through the taxi-choked streets of Kumasi. Perhaps this over 30-year confession will set my conscience free. I still regard this case a battle between conscience, wealth, and fame. I had set Kwarteng free, but not my conscience, the most unimpeachable of all judgments. I think stories like this is what makes them say all lawyers are liars, and that when lawyers die, they are buried upside down, which is not true. But I always think of the story of Jesus Christ and the adulteress and how she used the law to defend somebody who had clearly committed adultery. Even Jesus believed she had a second chance. How much more as lawyers who are trained to defend even the guilty? Well, if you found today's episode helpful, share it with a colleague, leave a review, and don't forget to follow the Diary of a Ghanaian Lawyer on your favorite podcast platform. This has been Lawyer Fredericka, and you've just listened to How to Cross-Examine Like a Pro. See you in court. Till next time, keep learning, keep growing, and keep advocating.